This American Dream segment is brought to you by Aquino & Lowe Law Firm, answering your immigration questions.
Attorney Allison Aquino, hello and welcome to Kababayan LA. You make me happy because every time you're here, we talk about something that's really uplifting, something that's really good on the immigration front, correct? And you have good news for us once again. BIA rules K-1 fiance may still adjust despite divorce. So let's talk about definitions here first. BIA is Board of Immigration Appeals. K-1 is
Fiance visa.
Fiance visa. Okay, tell us about the case of a matter of CICE.
Right.
Yes.
And so this was an appellate case that was decided a little less than a month ago, and it involved a gentleman from the country of Sierra Leone, and he was studying in Egypt, and he met a U.S. citizen. They fell in love, and when she came back to the United States, she went ahead and petitioned him for a fiance visa petition.
Okay.
He entered the United States pursuant to the fiance visa, but for an unspecified reason, he was delayed in filing his adjustment of status application for permanent residency, roughly about 10 months.
Okay.
The problem is that about, shortly after filing his application for permanent residency, immigration erroneously denied his application.
Why is that?
They made a mistake,
okay,
which sometimes immigration does.
Right, okay.
Later on, immigration admitted that they made a mistake, but the problem is that he and his wife were already divorced.
Okay, let's talk about this. Very interesting. So first of all, if a person, say for example, I'm a U.S. citizen and I want to marry somebody from the Philippines, I apply for a K-1 visa. When he enters, we only have a short window to get married, right?
Exactly.
What is that window?
The requirement is that the two individuals marry within 90 days of entry into the United States.
So 3 months. And then after we get married, do I have a limit? Does he have a limit as to when he needs to file for a permanent residency? Because it's not automatic.
It's not automatic.
Okay.
Exactly. So what happens is after the two parties get married, the individual still has to apply for permanent residency by submitting an adjustment of status application.
Okay.
There is no deadline as to when that needs to be submitted. However, of course, out of an abundance of precaution, you want to file that as soon as possible.
Earlier. Okay.
Exactly. Such as this gentleman, he waited 9 months.
Right.
And unfortunately, they started encountering marital problems.
Right.
And so typically before this case, if the two parties get divorced and the permanent residency had not yet been granted,
okay,
the person cannot obtain permanent residency.
Wow.
Okay.
So you have to file it as soon as you can because you don't know if the marriage will last.
You don't know. Hopefully it will.
Well, hopefully it's happily ever after. But yeah,
right.
Okay. So, and because this ruled in favor of the guy, now this is good news. Because
exactly.
What happens now to those that were turned down? Can they?
And so if people in the past had been denied, their adjustment of status application, they should go ahead and proceed with refiling another application based on that marriage.
Right.
What this case made specifically clear is that even though you're divorced, as long as the two of you got married within the 90-day period, that you are still eligible to proceed with obtaining permanent residency.
Oh.
And this case also clarified that that still applies even if the individual gets remarried to another U.S. citizen.
Oh, okay. Which individual? The individual?
The person applying for the green card.
Oh, okay.
Right.
Okay.
So if the person applying for the green card gets divorced, they can still apply for the green card. Even if they get remarried, they can still apply for the green card. And the reason that that's important is because there are very strict limitations on the fiancé visa.
Right, right.
So if a person gets a fiancé visa, enters the United States, gets divorced, and then they think that, well, let me just go marry another U.S. citizen and then apply for for the green card that way. And the laws are very specific, and this case makes clear that you cannot apply for a green card based on any other marriage other than the one who petitioned you for the fiancé visa.
Exactly. The first one who petitioned you for a fiancé visa, for the fiancé visa.
Precisely.
Right. Okay. Right. Well, you know what? It's so complicated, but thank you so much for clarifying things. I would still go with a lawyer. Even if you think you know everything, even if you research on the computer, I would still go with a lawyer because things change, laws change, and that's the number to call on the screen. They do give free office consultation. Or if you have additional questions, you may email us because we will have them answer your questions. That's Kababayan at LA18.tv. Thank you so much. More power to you. We'll be back more on Kababayan LA. Don't go away.
Cancer can be daunting. You're not sure what to do.